Hey, fellow patriots, I'm Bree.
And I'm Blaze. Some call me Pa. It has been said that we have 4 boxes to keep ourselves free. These are the soapbox, the ballot box, the jury box, and the ammo box.
And we are the 4th box. We are here to arm you with enough information, resources, and skills to take back your freedom, increase your self-sufficiency, and inspire you to join in the fight against tyranny.
Thomas Jefferson said, "Eternal vigilance is the price of liberty." Thank you for joining us and for joining in this fight.
Welcome back to the 4th box. Okay, everybody, welcome back to the 4th box. Tonight is a special episode, so before I pass it off to Dad for his cheers, I would just like to do my own quick cheers before we get into anything else. Pops, it's your birthday, so happy birthday. Cheers from myself and the rest of the 4th box.
Well, thank you. Thank you. I was afraid that was coming. Salute. We won't get into the age or any of that, but
no need.
Glad to be with everybody, all of our patriots and friends around the country that join us for these sessions. It's our 77th podcast. Proud to say we've been keeping this going for a year and a half now. It's been a great joy, many great guests, and I'm looking forward to having our discussion with our guests tonight. But I also am offering a toast, and I'm toasting tonight to a significant historical event. Back a few days ago, June 15th, was the 810th year anniversary of the signing of the Magna Carta.
Oh, wow.
Very significant piece of society's battle for liberty, and something that our founding documents certainly have roots back to the signing of the Magna Carta, which was done at the point of a sword by King John back in those days. So we're saluting that historical event today. And then furthermore, for my quote tonight, I said, imagine this quote. I'm not even sure where it came from, but I found it in one of my readings the other day, and the author was unknown. Imagine a government operated so poorly they had to import an entire nation of new voters because they lost the citizens' vote. I thought that was remarkable. A one-sentence description of where we've gotten to, but that the author is unknown of that quote, but I thought that was especially fitting for the conditions which we find ourselves in today. So that was my quote. With no further ado, Bree, you can bring our guest in. Very excited to hear what Andrew has to say.
Yeah, absolutely. Thank you for that. Thanks for the cheers and the quote to get us started. So tonight, we are honored to be joined by Andrew Langer, a leading voice for regulatory reform, economic freedom, and the protection of individual rights. Through the years, his work has focused around government accountability, revealing how government regulations impact small businesses, individual liberty, and the economy of the country as a whole. His many projects center on exposing government overreach and pushing for greater transparency and constitutional limits on bureaucratic power. He spent decades fighting to limit the power of unelected bureaucrats and ensure government stays within its constitutional bounds, which, as you all know, is so important to us here at the 4th box. So, Andrew, I'm sure I barely skimmed the surface, and I know that was a fairly broad introduction. I'll let you take it away.
No, I mean,
tell us a little bit more.
It's a great introduction in that, so many introductions sound like obituaries when you read them, and as they say on the old Gilbert Gottfried podcast, died alone, surrounded by his cats. First of all, Blaze, happy birthday to you. That's exciting. I'm honored that we're able to celebrate with you this way tonight, and happy birthday to the Magna Carta. I just spent some time over in the UK back in March, touring North Wales and learning about that history and the fight for freedom that still goes on there, and spent a lot of time talking to not officials but public policy people in the UK, and again the struggles that they're having. No, I mean, listen, it's a pleasure to be on. I am literally been spending a lot of time talking about this issue of the unelected bureaucracy and how we rein that in. And one of the things that I am guided by touchstone, a North Star for my work, is a 1992 Supreme Court decision by the Supreme Court, but written by Justice O'Connor, New York versus United States, in which Justice O'Connor wrote, "The Constitution protects us from our own best intentions. It divides power among sovereigns and among branches of government precisely so that we might resist the temptation to concentrate power in one location as the expedient solution to the crisis of the day." And that is a quote that has guided all of the work that I have done up to this point, and obviously beyond, because it sums up everything about our republic. Ours is supposed to be a deliberative republic. When we concentrate power, rights can get abused. Policy made in a crisis is invariably bad policy. We could talk a lot about that, but that's the short introduction of me.
Yeah, amazing. Well, I already know that my dad's going to say, "Oh, we love that you said republic and not democracy,"
Oh, yeah.
because we really try to make
Sure.
that clear on this show. Pops?
Yeah, so I would suggest, Andrew, that largely we have lost the republic and we're making an attempt to reclaim it, as I think we've operated more as a democracy for many, many years now, in addition to being well outside of the 18 specific delegated authorities that Article 1, Section 8 displays, supported by the 10th Amendment. But more importantly for you, at least as we're getting started here, I'm interested as to how you became involved and such a champion of things that we find very near and dear to our hearts here at the Fourth Box.
Well, listen, you are allowing me to expound upon my absolute favorite subject, and that would be me. No, so I was really fortunate. I came to my conservative or conservatarian values through ardent anti-communism. I went to college in Virginia at the College of William and Mary because they were one of the two best Soviet studies programs in the country at the time. I wanted to go and learn Russian and learn Soviet studies because I wanted to go and fight the Russian bear. And then in the middle of my junior year of college, the Soviet Union up and disappeared. The summer of 91 had the big coup, and things fundamentally changed. In the fall of 92, Bill Clinton was elected president. He eviscerated the intelligence budget, and my sort of ambitions in that regard went by the wayside. And I wound up going and working for a law firm in Washington, D.C. I'd worked for a law firm in New York all through high school and college. And this was the law firm that was going to open up the first office of an American law firm in Moscow. One of its founding partners had been the U.S. ambassador to Russia, the U.S. ambassador to the Soviet Union. But along the way, they sat me down because I'd done college radio, and we haven't talked about it yet, but I do radio these days too. But I'd done college radio, and they asked me if I could sit in and substitute for one of the partners who was blind and work as his reader and personal assistant. And as it happened, his area of expertise was private property rights, and sub area of expertise was public lands issues and the balance of power and regulatory issues. He had run an organization called Mountain States Legal Foundation, which is one of these nonprofit legal foundations, this one based in Denver, and then had written President Reagan's executive order on takings as the assistant attorney general in charge of the lands division. And so I got this graduate education in environmental and regulatory policy and constitutional law, and it set me on this very different path, and I became very passionate about those issues. So when I eventually left the law firm, I got a little burned out. His wife hired me. She was running a small nonprofit organization called Defenders of Property Rights. And we worked on a case representing a county out in Nevada, Nye County, the third largest county in the United States, the size of Vermont, New Hampshire combined. And they were 93% federally owned. And the impact of the federal government on this county, I mean, all of these things just had such a massive impact on me. I then read David Bose's Libertarianism, a primer or a primer, depending on how you pronounce it. And I understood that was really where my beliefs were. Now, I've become a little bit more conservative over the years, but at least at the time in my mid-20s, I was very solidly small L libertarian. And so that's how I came to be doing what I'm doing. I worked for Defenders of Property Rights and then a think tank called the Competitive Enterprise Institute. I was the executive branch lobbyist for the National Federation of Independent Business, and so on and so on and so on. And so that's it. Very passionate about these issues, and passionate about, I think, some of the things you guys hold dear. These first principles of constitutional law, things like due process, and the erosion of individual rights in the face of an expanding bureaucracy, the erosion of the concept of mens rea, something I talked about today with Ilya Shapiro from the Manhattan Institute, the idea that criminal law has to have a specific intent in order for something to be a crime. Um, and getting into eventually this idea that as the regulatory state is so expansive, and again, another aphorism from me is every time government expands, individual rights diminish. But this idea that when government gets so vast, as Henry Silverglade put it, the average American commits 3 felonies a day. The law can be weaponized against any individual. And so these became a lot of the things that I've been passionate about over the years.
Yeah, that's fantastic.
Thank
So
you.
much of what you're saying aligns so closely with the things that are so important to us.
Right,
Pops, I know you're ready, so go for it.
Yeah, well, one of the things, Andrew, as you were discussing, piqued my interest in particular, as you mentioned, property rights advocate and the very different organizations that you had participated with. A couple of the guests that we've had on several times, I don't know how familiar you are with the carbon sequestering pipeline,
sure.
CO2 pipeline. Yeah, so several of our guests, or our guests, several occasions, are involved in the middle of this, specifically up in South Dakota, and we're largely involved with reshaping some of the state politics up there in terms of complete refacing of their state legislative body, and in an effort to hold off what they believe to be grievous offenses on property rights. I wondered if you had anything that you could share that you may have experienced or know about those conditions out there in the Midwest.
On that specifically, no. I mean, I will say this much, right? Over the course of about 150 years, the concept of public use has been massively eroded. And to their great credit, say what you will about Charles and David Koch, Koch Foundation, Koch Brothers, and Koch Industries, when they were building pipelines, they never used the power of eminent domain, right? They always negotiated with the landowners directly, and it, of course, created a crazy pastiche, but they were so enamored, and rightfully so, of private property rights that they never went out. In fact, it's funny, one of my mentors for many years was a gentleman named R.J. Smith, who ran an organization called the Center for Private Conservation. And we're at an event at the Kelo Institute. This is probably 20 years ago. And an attorney for the Natural Resources Defense Council was in the audience. And he stands up and he says, Mr. Smith, for many years you have touted this statistic that the Koch brothers have never used eminent domain to condemn any land for their pipeline. And I'm thinking, I'm catching my breath because I'm waiting for him to prove RJ wrong. And he says, and I just want to let you know that I have done a great deal of research and I have been unable to disprove what you have said, which was, a great moment. The bottom line here is that, when we grant the power of eminent domain so that private entities can benefit from it, again, this is a power that can be abused, it can be politicized, and it doesn't serve the public very well. Let's remember that the federal constitution, and it's echoed in many state constitutions as well, requires 3 elements for a property rights claim, right? They require, obviously, they require just compensation. I'm going for the third one first. They require due process to have happened. That the landowner, the property owner, has the ability in some actual legitimate hearing to state the case as to why their property ought not be taken. And then at the very basic level of it, it has to be for some kind of public use. And unfortunately, over the last 150 years, that definition of public use has been so thoroughly eroded The famous case from 20 years ago, this term now, the Kelo case, Kelo versus the city of New London, in which this woman had bought a cottage on the Thames River in New London, Connecticut. It was being taken so that Pfizer, what's past is new again. Pfizer could bulldoze over her house for a parking lot. And the good folks at the Institute for Justice challenged this. And unfortunately, because there had been at that point 150 years or 130 years of Supreme Court case law, the Supreme Court on that issue of stare decisis, reliance on precedent, the Supreme Court said, well, no, public benefit equals public use. Therefore, we're going to find in this way. I dare say, I would hope that 20 years down the road with a changing face of the Supreme Court, maybe we could get that revisited. But it's also why I have always held a dim view towards the slavish devotion to the reliance on precedent. It tends to be in the same way that folks say that patriotism is the last refuge for scoundrels. Stare decisis is the last refuge for cowardly jurists. So no, with the specific area, I don't, but there are huge problems that ensue from the private to private eminent domain.
Mm-hmm.
Yeah, for sure. And I would say we're seeing a lot of that with the push for green energy, right? Because there's so much with not just the carbon pipelines, but solar panels, et cetera, where they're coming in and claiming, oh, this is for public use. To your point, it is not for public use at all. Maybe you can touch on a few other examples that aren't so glaring. I think that those ones people are seeing a lot right now. We just had that case in New Jersey, I think, where they used eminent domain to take that farm,
right? But where they're trying
affordable
to right
housing.
Now, that's this is the one that I tweeted out about the other day, which is here we are, 20 years down the road from Kelo, and this stuff is still happening. I mean, here's the thing. There are lots of instances that are out there of this kind of private to private eminent domain. The reality is that in a number of states, New Jersey not being one of them, in the wake of this, have passed laws underscoring what public use means. We could in America define in the same way that the United States Code defines what a member of the militia is for the purposes of frankly the Second Amendment. We could define public use in statute, but we haven't quite done that yet. In fact, I need to get back and Harriet Hageman, the congresswoman from Wyoming, is doing an Article 1 task force right now. That would be something to raise. Is yet another thing that they ought to be doing. But in terms of property rights, I mean, here's the reality. The reality is that there have been many great strides that have been done in dealing with, whether it's the court cases that have limited the scope of federal power, especially when it comes to wetlands or waters of the United States. There's a much greater understanding of this today, and then we are 30 years into what is ultimately, I think, going to be a 6-decade effort to take our laws back to the center where they were. That between the 1930s, the beginning of the New Deal, and the 1990s, we had this unrelenting movement, leftward, an unending expansion of federal power in a whole host of ways. But again, a series of cases like New York versus United States and a few others in the 1990s that really started to push back against this expansive nature of federal power, culminating in last year's Loper Bright relentless decision on Chevron, which has, really has some important implications for reigning in the administrative state.
Pops?
Yeah, so I want to go way back. There was.
What's that?
I want to go back.
Go ahead. Go. I'm sorry, Blaze.
No, that's all right, Andrew. Go ahead. You're on for us to hear you.
I know it's a lot to digest. I tend to go down that road, so please, I'm happy to do the dialogue.
Well, I want to circle back to a point you made about a county, and I think you suggested it was in Nevada, maybe the third largest county in the country.
9 counties.
So much. So much of it is under the possession of the federal government. And I wanted to talk to you specifically about that. My understanding and reading of the Constitution would suggest that there should be no federal lands that are allocated to the federal government except that which were presented or made available by the individual state for the use as a military institution, be it forts or arsenals.
Yeah, I mean, it gets a little bit more complicated than that. I mean, we could discuss the constitutionality of things like interstates, but let's start with this idea that the Fifth Amendment, in the most, I'm sorry, not the most expansive, but the Fifth Amendment at its core is, we give the federal government power to own land, right? And to take that land for a particular public use, provided that, as we've said, due process is accorded to the landowner, just compensation is paid. It got a little bit more complicated once the U.S. started acquiring territory, whether by treaty or by conquest. Or purchase. So the Louisiana Purchase was one way of doing this. The purchase of Alaska was another. The 1848 Treaty of Guadalupe Hidalgo was another. And so the U.S. acquired all of this land and carved out these territories. And as the territories started to become states, each state entered into a contract with the U.S. And the idea was that in order to make it easier and streamline and to get rid of confusion, these territories would clear title to the federal government, right? They would get rid of the unappropriated public lands that were controlled by the territorial governments. They would convey them to the federal government, and then in most, and not all, there are some specifics that, frankly, I honestly don't remember which specific states. They're all almost the same, but there are some differences. But they almost all had this agreement that the federal government would dispose of this land, and that the states would be given the 15% of the proceeds, and also the state would be given a certain percentage of this land for things like public universities and other educational institutions and state government and the local governments. They would get a certain amount of this land, but that there was this duty to dispose. And for many, many years that was there. The problem, of course, was there was a lot of land that people didn't want to buy. Now, of course, we now know that all of these lands have value in some respect, whether it's for recreation or whether it is for resource extraction or what have you. But in the late 1970s, there was a change in posture. There was the passage of something called the Federal Land Policy and Management Act, FLPMA. And FLPMA literally flipped that duty to dispose on its head, and it created this duty to retain. So now it becomes very difficult to dispose of property. And as we know, the federal government is acquiring land, and it is changing the designations of those lands and making it very difficult to dispose of, to the point where we actually don't know what the federal government owns. In the same way, we don't know how many regulations are on the books and the actual scope of the federal regulatory state. It is so vast, we don't know what the federal government owns. And of course, this creates huge problems in and of itself. So you get folks who are carping that in the reconciliation bill, there are lands that are being sold off in, I want to say I just was reading in near Monterey, California. It popped up on a Reddit group that I was reading. And obviously folks get all bent out of shape when anybody starts talking about disposing of the land. The problem, of course, is the federal government's a bad manager. They don't manage that which they own. It's so vast they can't manage all of it properly. And then there are huge impacts for the localities themselves, whether it's because they can't make decisions, as was the case in Nye County, Nevada, or because there are vast amounts of land in which the localities are being vastly underpaid because they can not levy property taxes. They only get these things called payments in lieu of taxes or PILT payments. And that's an issue. With Nye County, it gets a little more complicated because there were a series of laws passed in Nevada at the same time the Federal Land Policy and Management Act was being passed, in which the state declared that all the unappropriated public lands should revert to being under the control of the state because the federal government had reneged on their agreement, right? I think that there's there's an ongoing contract dispute that the statute of limitations never runs on because the injury continues to this day for the federal government's breach of their duty to dispose. And a couple of folks have talked about pushing that. But the bottom line is, it came to a head in Nye County in the mid 90s. The Forest Service closed a road between two of the major towns, and these are towns that are separated by probably 100 miles. And so folks were having to go, 200 miles out of their way to get from point A to point B. And a county commissioner got so frustrated that he went and bulldozed open the road on the public lands. And the federal government then sued him personally and sued the county. And we were asked to come in. Now, the problem with that case at the end of the day was that we asked the state to intervene because they should have been acting under color of state law. And then Attorney General of Nevada said, nope, I don't believe, my office doesn't believe that this law is a legitimate law, so we're not going to enforce it. And so that kind of did our case in, but it underscores the point that so many of these counties out west, and it's usually west of the Rockies, obviously west of the Mississippi, more and more lands are publicly owned or government owned, I should say. You get towns like, oh good Lord, it wasn't Tombstone. I want to say it was Bisbee, Arizona, where there was a water pipe connecting the town to the municipal water supply or the state water supply. And the pipe was crossing wilderness land, and the pipe broke, and the federal government under President Obama wouldn't let the municipality repair the pipe, and literally putting it, so there wound up being a bucket brigade, like funneling in water. Now, I will say, I don't do a lot with these kinds of public lands issues. I obviously I'm very interested and still passionate about them, but my areas these days tend to be more focused on the administrative state than anything else.
Yeah, and I definitely want to get into that. I mean, I think we could talk all evening just
sure.
about the property rights stuff,
100%.
but obviously there's so much here we can dive into.
Yeah.
This is just a great explanation or
Right.
example of, one of these things that there is so much overreach on,
Right.
but go down any path, there's too much overreach. Get stoves in your home, the car that you drive, the farming equipment you're able to use. Feel free to elaborate on any of those.
Let me go here for a second on the property rights issue, because one of the things that we've dealt with for many years was something called what we would call regulatory takings, which is where regulations serve to take people's property from them. And a gentleman who's now become a friend, Donald Koshin, he's a professor of law at George Mason University. He calls them, he thinks the term is wrong and a little inartful. He calls them involuntary regulatory servitudes, because essentially it's like a leasehold interest, and it gets at certain aspects of your property, because it's been all too easy for the government entities to argue that what they're not doing is taking the property. They're just putting encumbrances on them. And in any other aspect, if the federal government or any government entity started encumbering your property, they would have to pay you for that encumbrance. And so, he likens them, he calls them involuntary regulatory servitudes. I mean, here's what we know, generally on the administrative state. We know that the regulatory state has grown vastly, that this is really that expression of government power that we've been talking about, executive branch power, which to me is the great threat to individual rights, because it can be abused. We know that under President Trump's first term, the regulatory state only grew by 1/3 per year for the 4 years he was president. That's unprecedented in the modern era. George Bush grew the regulatory state by about 10% while he was president. He was, next to Reagan. Well, I don't think we've really run the numbers on Reagan, but, basically since Reagan, George W. Bush was supposed to be the most deregulatory or anti-regulatory president. He still grew the regulatory state by only by 10% during his term. President Trump inherited a regulatory state that had doubled in the 8 years of the Barack Obama administration, from $1.1 trillion annually in direct regulatory costs to $2.25 trillion. And when he left, it was $2.28 trillion. You'd only added $30 billion in regulatory burden, and even that is probably wiped out due to inflation over time. Joe Biden becomes president, hits the gas pedal again, and the regulatory state was growing by about almost 15% per year, and it almost doubled in the 4 years that Joe Biden was president, from what did I say, 2.25 trillion to about $4 trillion annually. And it's not just my work, but the work of my colleague Dan Goldbeck over at the American Action Forum. I was talking to him today about this thing called the REINS Act. His numbers jibe with my numbers, so of course I think they're right. But that's what we get to is when you have a Congress that's unwilling to take control and pass specific pieces of legislation, when you then have executive branch agencies that have enormous power of deference, not just to interpret statute, but to interpret their own regulation, when so much of it is unaccountable because of what my buddy Wayne Cruz at CEI calls regulatory dark matter. It really creates a horrible mix. And then you add into it the issue of debt and spending. Let me just real quick add into this. The work of my colleague Matthew Jensen at the America First Policy Institute. He talks about the issue of the fiscal impact of regulation, i.e., if you grow the size of bureaucracy, there's a fiscal burden, but also the more rules you put on how the federal government spends its money, that's a fiscal burden. I had a conversation with somebody at Freedom Fest over the weekend about putting the two together, the issue of debt and deficits and regulation and the toxic mix that creates, and the relationship between the two. We're just at the advanced stages. I obviously haven't reached any conclusions on this, but clearly something needs to change.
Yeah, I would say that's an understatement based on all the info you've given us so far.
Yeah.
Pops?
Yeah, Andrew, I was interested specifically as you were describing these different administrations and how they grew in comparison to one another. What are the measurables that are used there? Is that a monetary thing, or is this number of regulations? It's monetary.
It's a cost estimate, right? And you sort of looking at based upon the Federal Register and based upon the baseline and based upon the tempo. So for me, I start with I start with the cost, right? I go back and I start with the cost of regulation when George W. Bush took office, and go from there, given the number of regulations that were issued and the attempts to quantify the economic impact of those regulations, and then you come up with a number at the tail end. So you go from 700. Never do math on the air. Let's go from X, and you wind up with 1.1 trillion when George W. Bush leaves office. And then you look at the tempo of regulation over the course of Barack Obama. You look at the major rules that are issued, and then you come away and you say, okay, well, he went from 1.1 to 2.25 trillion. And some of this is also based upon the extrapolated numbers out of the SBA, so the Small Business Administration's Office of Advocacy. Up until about 2010, they were responsible every 5 years for doing a report on the impact of regulation on the U.S. economy. And when we saw the massive jump when Barack Obama took office between then and 2010, 2011, the Obama administration stopped producing the report. And so it wound up going, the folks who put it together wound up doing it for the National Association of Manufacturers. And it was the same metrics and went from there. So we go from there, and you look at this and you see how the numbers jibe. My colleagues at CEI, they use a slightly different metric. They're looking really at major rules and how those get expressed. So, the percentage growth is the same. They're just using different starting and ending numbers than I am. So their numbers, their overall aggregates. It's funny because part of what I was talking about with Dan Goldbeck today was the issue of whether or not it's come time to also express regulatory costs in terms of time, especially paperwork costs, because time is a finite resource, as they say in the movie Star Trek Generations. Time is the fire in which we all burn. It's the one thing we can't make more of. And so, I think that there ought to be some kind of a no net loss of time metric in terms of paperwork, that if you're going to add 15 minutes of paperwork burden on an average regulated entity, you need to take it off somewhere else. We've done these, opportunities before on the public land side of it. No net loss of private lands, as there is a move to acquire or control 30% of the land mass in the United States by 2030. So I know there's something a little gimmicky about these kinds of pledges, but nevertheless, maybe we should be thinking about a no net loss of time pledge. Maybe we ought to be thinking about a no net loss of private lands pledge.
Well, I think it's really interesting to be thinking about the small business impact as well. Obviously, that's a big part of what you do.
Yeah.
And while I find the metrics really interesting, I think that for a lot of people, they're not really understanding like what is the real world crossover here. Can you kind of like give us some examples of how this translates to real life?
Oh, sure. I mean, it could be any one of a number of things. I mean, we're talking about when I talk about small business, I'm talking about businesses with 20 employees or less for the most part, because that's 90% of the businesses that are out there. Average employee size of about 10 employees. Once a business gets above 20, and usually when they get to about 30 or 35, they're hiring their first regulatory professional to handle this issue of paperwork and noodling through what their obligations are. But up till that point, it's usually the owner of the business, the owner's spouse, or some non-professional who's dedicated to dealing with these rules and regulations and having to figure out what their compliance requirements are. Now, I mean, it could be as simple as wage and hour paperwork and making sure everybody's getting paid in the right way, who needs to get paid, who is a contractor, who is a part-time employee, who's due overtime and who isn't. If you're in a medical practice, there's the paperwork that's involved there with insurance and compliance. It can be as straightforward and burdensome. This is something I worked on when I was with NFIB. There's a paperwork rule called the Toxics Release Inventory, the TRI. And the TRI is really just a chain of custody paperwork. If let's say you are a small pottery shop owner and you buy glaze that has lead in it, you have to keep track of how much of your glaze is used. And that's a hugely cumbersome process, right? It's not as simple. It's like measuring, how much is left in a jar at the end of a day, or however often you have to do the piece of paperwork. But keeping track of this and then submitting it to, the EPA, and no one can determine what the benefit of this is the public better off by some poor ceramic artist measuring his or her glaze content? Or again, coming back to lead, because lead can sometimes be a massive boogeyman. If you are a home renovation business, training your employees to abate, lead in window repair, right? Lead in home paint and those kinds of rules. So, I mean, it's myriad. It's not just environmental. I mean, it can be just about anything. Every agency has its paperwork burdens, and that's the other thing. There's been a lot of time talking about context with this and getting the federal government to think better about this. Any average, and let's give them the benefit of the doubt for a second. Any average civil servant, let's assume that they have the noblest of intentions for a moment. You go into this because you want to serve the public. The reality is they don't really understand the context of whatever burden they're putting on within the context of anybody else's burden. And so one of the things that I have long time proposed is that, once a year, they're doing training. We could talk about all kinds of politically motivated trainings that folks do in these agencies. But how about when they're doing this training, how about they spend an hour talking about understanding the regulatory burden of small business? And the suggestion that I've made, and I literally just made this to somebody, in the administration, is once a year when you go in for training, if you're a bureaucrat, you're given a task where you have 1 hour. You're given what's called a NAICS code, the Industrial Classification Code for a business. You're given the business size, you're given the location, because sometimes these regulations are determined by where the business is located. And you have an hour to figure out every regulatory mandate this small business has to face, right? Just to get a sense as to what a small business owner has to go through to figure these things out. Now, there are other tools that we're talking about engaging in because it's 2025 and it shouldn't be this opaque anymore. And yet it is. Given what we now understand what AI can do, there's no reason why a small business owner can't go on some portal and enter in a few key pieces of information about their business and have some website spit out every mandate that they have to comply with in some kind of plain English compliance guide, along with a way to fill out that paperwork. And if they need to fill out the same information to populate it, there's no reason why we can't do this today. But that would, I think, expose the ridiculously of this, or it could undercut, the belief that there isn't a problem out there, which of course there is. So we're having these conversations with folks in the small business advocacy world, because that's important.
Pops, I know you've got something there.
Yeah, I'm really curious. I mean, you spend an awful lot of time immersed in these regulations.
Hold on for a second, Blaze. My one of my pups is going to come up and say hi because.
Oh, okay, very nice. Yeah. Oh, hi.
This is Charlie. Sorry.
Yeah, no.
Charlie.
Okay,
Charlie hears me talk. He gets jealous.
Anyway, he wants to be part of the show.
Yeah. There you go.
Yeah, I love the bandana.
Yes, he just went to the groomer. Sorry, so go ahead, Blaze. Spend a lot of time.
Yeah, so you spend a lot of time with these different groups that are involved with studying all these regulations and all of these things, and I wonder if anybody has ever considered how many of these things that we're all forced to comply with, regulations, you're discussing things within business, and we deal with lots of them ourselves in my particular work, but how many of them fall within a specific delegated authority? Have we just thrown that all away? To me, it seems like
we have not thrown that all away. In fact, that's a huge aspect of the work that I'm doing now with the Center for Regulatory Freedom is pushing back on these things. Here's the thing. I mean, part of this is now thankfully open to discussion under this Loper Bright decision, right? Let me real quick explain. So for 40 years, agencies were given discretion in terms of how they interpreted the statutes. Now, there's a whole other form of discretion. We won't get to that for right now and confuse the issue. Under something called the Chevron Doctrine. And the Chevron Doctrine at its essence said that whatever an agency says in terms of how to interpret statute, unless it was completely ridiculous, the agency's interpretation would stand. And slowly but surely, we chipped away at this until, West Virginia versus EPA a couple of years ago, which basically said that you can't force a whole new interpretation, a whole new regulatory regime through small bits of language in the statute, right, in terms of dealing with the EPA. Then Loper Bright comes along and says, something, no, this Chevron Doctrine is ridiculous and something needs to be done about it. Now, the Supreme Court said specifically, this is not going to overturn any existing regulation. Right? We don't want to open up that Pandora's box. That being said, the way the administrative process works, and let me know if I'm too far away from my microphone, guys. I hope I'm okay.
No, you're
good.
The way the administrative process works is that anybody at any time can petition an agency to reopen a rulemaking and to get at these issues. So if there are interpretations that are on the books that folks think go well beyond the scope of what the agency is authorized to do, then they can petition to get things reopened. And there are a lot of folks, not just us, who have done that with the agencies. We've done it on a few key things. This is not a delegation issue, but we've petitioned the Office of Management and Budget to reopen their proceedings from during the Biden years on how you measure the costs and benefits of regulation, which I can get into if you want. But the point is, when we file comments now, I mean, before Loper Bright, we would invariably say that this interpretation exceeds the actual statutory authority, that you don't have the power to do what you're doing here. Even more so now. And what's been really interesting is that a number of agencies have in the new administration. So a lot of folks are concerned that DOGE didn't do enough on regulatory reform. And I get it. We were hoping that a lot was going to be done, but DOGE was really focused on personnel and the size and scope of the federal workforce. It really wasn't focused on specific regulatory regimes. And now that we're getting the senior political appointees going in, all of these agencies are putting out what are called requests for information. They're looking for recommendations on practices that are anti-competitive and exceed the scope of the agency power. So we've made a number of recommendations at places like the Department of Transportation, Homeland Security, EPA, et cetera, where we think that the agency is abusing its power, going well beyond what it needs to do, while at the same time petitioning agencies in other areas where they need to reopen things. There's a lot of debate over what's called the Administrative Procedure Act, the APA, whether or not the APA is valid, whether or not it's an impediment to reform. I believe in the APA. I believe that it's a process that exists to help protect, or it's supposed to help protect the rights of the regulated public, because it creates a standardized way of commenting. The real problem we have is when agencies engage in this regulatory dark matter, create policies that have the force and effect of regulation, but don't go through the same kind of notice and comment. The beautiful thing about our system is, if the agencies do what they're supposed to, they create a proposal, they put it out to the public, and the public has X number of days to comment on their proposal, and the agency is required to either address whatever substantive point is made and either change their proposal to reflect the substantive point, or to demonstrate why they didn't. And if they don't do it, that gives the grounds to challenge the final rule. You cannot challenge a final rule unless you file comments in advance. And one of the examples that one of my mentors likes to use is the off-road diesel rule, or the emissions from tractors rule at the EPA. The EPA proposed that in order to get at particulate matter from tractors, that every tractor be retrofitted with a box to put on its engine. And they were moving, ever forward on this until a real person, a real farmer said, "Hey, I appreciate what you're trying to do here, but I'm looking at my engine cowling and I can't fit this box on my engine without, and to be able to shut my engine." So it gets to something else that I like to say. The most well-intentioned policies eventually bump up against very real realities. Now, my dad says that's too complicated. My dad, who taught me what I know about risk and public policy, my dad said, "Andrew, the simple way to put it is there are many roads to utopia. However, all must traverse the surface of the earth." And you can't break economic law. You can't break cosmological law. The laws of the physical universe. I'll give you a really good example of this. I'm at CEI in the early 2000s, and this is at the early stages of the EPA proposing its corporate average fuel economy standards. And a colleague of mine said, this is all well and good, but the EPA doesn't realize that you can't have it both ways. If you have a more fuel efficient engine, gasoline engine, it's going to emit more CO2. I'm like, what? He goes, yeah, because if you crack a hydrocarbon atom properly, right, you're going to produce the energy, but you're going to get CO2 as a byproduct of it. And so the more efficiently you crack it and you deal with the carbon, you're going to get the CO2 emissions. And so it was really interesting when a couple of years later, Volkswagen announced that they had that they had developed a diesel engine that could be fuel efficient, could pollute less, but also wouldn't sacrifice any engine power, wouldn't sacrifice any horsepower. And we all just sort of looked at it. We said, boy, how the hell did they do that? Again, this seems to violate the laws of physics and the laws of physiochemistry. Well, it turns out that they didn't. That it was they ginned up their software so that anytime it would detect when it was put on a tailpipe emissions monitor, and it would do all the things that it said it would do, but it didn't actually do it. So you can say it this way: you can't cheat the universe. God will not be mocked, et cetera, et cetera, et cetera. But the most well-intentioned policies, right? Whether it's immigration or whether it's tariff policy, right? I'm someone who understands what we're trying to do with tariffs, right? But you can't have all three things happen at the same time. You can't repatriate jobs and raise revenue and get other countries to enact more fair trade policies. One of those things at least has to give at some point in time. Now, it's my hope, right, that the unfair trade practices are the ones that give. But if those don't change, well, then we either repatriate jobs or we get revenue. But you can't do all three at once.
Yeah, for sure.
Yeah.
So we jumped around a lot there, but I want to go back to, Dad, what your question was originally, and I want to reframe it because I know what you were thinking.
Okay.
And so I'm going to go back to that a little.
Yeah, so go ahead.
Well, you did answer the question, Andrew, but I think if I am putting my head in my dad's brain for a moment,
Okay.
I think he would then say, Pops, you can sure correct me if I'm wrong, but I think I'm right. You would say, well, none of these regulation reforms would be necessary if the agency didn't exist to begin with, right? And to your point, Andrew, the road to hell is paved with good intentions, right? It doesn't mean these agencies didn't once begin and once have a couple regulations that were meant to be good for everyone. But in time, it's expanded and ballooned into something that is uncontrollable and, as you said, immeasurable.
Right.
So I guess my question to follow up on that question that you asked earlier, Dad, would be, what is the solution to that? Because from our outside perspective, you brought up Doge. It looks so easy to sit here and be like, oh, well, this agency is spending all this money, waste, fraud, abuse, blah, blah, blah. But you've been dealing with this very up close for a very long time. Right. So I think you can see a little more clearly that these processes probably aren't quite as easy as it looks for us to just be like, cut, see you later.
Right. Well, I mean, listen, there are a lot of different ways to sort of skin this cat. My colleagues in Idaho have zero-based regulatory budgeting, which means that every year or every legislative session, the bureaucracy has to justify its existence. Now, I like that very much. I'm not sure it can actually be done here. My issue is that unfortunately, there is a certain degree of deliberation that has to happen, and I understand this, right? If we take too much time, eventually the folks who are supposed to be doing this fight, they get captured by the system, right? They get enamored of being in DC. John Fund said, I was at a couple of events with John Fund last week, the writer and TV pundit from works with Unleash Prosperity, right? Unleash Prosperity. He said, you go to drain the swamp and you find out that it's a really nice hot tub. And so you want to drain the hot tub. But on the other hand, it does take good people getting into leadership. It takes a decision that has to be made. Now, it starts with this idea, I think, that you go to the agencies and you put the mandates out there to say, here's what I want it to look like down the road. And I don't care how you get there, but this is where we're going to go. And I think some of that is what we're seeing in terms of these requests for information, right? Unfortunately, you get folks who get in there and they don't necessarily know where all the bodies are buried, right? One of the problems you have is with our side is that the folks who are most skeptical about government, and rightly so, they're the ones who are least likely to go in, or some of the most least likely to go in and engage in that reform. Why go in there and become part of the bureaucracy and get captured by the system or bang your head against the wall? David Bernhardt wrote a book about this. He was Secretary of the Interior, called "You Work for Me," dealing with the frustration of the bureaucracy. To me, there are a few key things that have to happen, and I think it starts with getting control over what we have, and then soliciting the regulated community for recommendations and things they ought to peel back on. So that's why we're seeing all of these agencies put out requests for information, and I'm sending, pages upon pages of documents into these agencies. But at the same time, it's getting the agencies back to understanding their obligations, and I don't mean just agencies like the EPA. Like at the SBA, you have you have a chief counsel for advocacy and an office of advocacy, and they're charged under two really great federal laws, the Small Business Regulatory Enforcement Fairness Act and the Regulatory Flexibility Act, with analyzing new regulations for their small business impact. They're the only entity within the federal government that is statutorily enabled to challenge the regulatory decisions of other agencies. That's amazing. We should be expanding their role. By the same token, once the regulations are put into place, there's an office of a national ombudsman for small business, and they're an inspector general writ large. And at their core, they are supposed to be, if you think that an agency is abusing its power vis-a-vis you, you can complain to them and they will investigate. And they do a really good job. I think that their role should be expanded massively to deal with things like training and grading agencies based upon how they adhere to these small business laws, RegFlex and SPREFA. When agencies abuse their power, right? One of the great problems we have with federal agencies and their enforcement power is that all too frequently the agencies are not just the sort of the interpreting regulation. They're the legislators, but then they're also acting as their own quasi judiciary. They can engage in enforcement actions, and all too frequently in these agencies, their track record is such where they're winning 75, 80, 90, 95% of the time. And there's nobody who's acting as a watchdog. I think that the Office of the National Ombudsman should be acting as a watchdog. And what I love is the fact that this administration seems to be taking recommendations like that seriously. We need to be doing a lot better as a movement in terms of letting folks know what sort of rules and regulatory proposals are out for comment. That's something I've been talking about for a while now, that we do a really good job as a movement in commenting on major rules. We do a good job in particular issue areas like the environment or energy. But we do a very bad job at your run-of-the-mill regulations. And invariably, we do a bad job at letting our friends and allies know what's going on. I am trying to take steps to change that and get more coordination on the part of these outside organizations in terms of their regulatory involvement. Because that's the only way to do it, right? Right now, the way the system is, I think it takes a certain degree of deliberation to make sure that we don't make the same mistakes going the other way. So that's where I am in all this.
Yeah. Well, it's very easy for the mass majority to get bogged down with all of the noise and the political theater. And I mean, look at everything else going on today. I mean, we have, Middle East problems. Right. We have immigrant problems at home. I mean, there's so much that you are distracted by constantly that it's very hard to focus on the things that actually are really hitting home with you day in and day out. And you're not even realizing that these regulations are making that impact.
Well, if you're a small business owner, you are, because you're having to deal with this stuff. And I think a lot of us, just sort of in terms of our day-to-day work, the good folks at the Mercatus Center have been really good at trying to tell the story about how it impacts folks in their daily lives, the cost of regulation per family. But I think if you're a restaurateur, you've seen it. You've seen the energy costs spike. One of the great examples I like to use is if you own a pizzeria and you had a coal-fired or a natural gas-fired pizza oven, having to turn around and face the possibility of having to change that out for an electric oven, that's a huge expense. And that's a lost opportunity cost, which is the other part of this is, we forget that it's not just the direct regulatory cost that it's an issue, but a small business owner, if they're forced to use their resources on X, they're not using it for the productive part of their business. It's what we call the broken windows theory. If you have to spend money to repair broken windows, that's money you can't spend on new productive equipment for your business or people.
Right. Yeah, Dad, go ahead.
Yeah, Andrew, I know we've burned through an hour here already, but I have a question.
Please.
Since I think we're all looking for ways to reduce the impact of regulation, most of which I would consider to be completely out of constitutional bounds, what do you think about the 10th Amendment as a tool? Not that I have any states that are ready to stand up because they're all groveling for their pittance, but what do you think about the 10th Amendment as a tool, followed more closely by the Mac Prince versus U.S. case that would suggest that states are not subject to federal direction?
Well, I mean,
what do you think?
I mean, the Prince case really, the Prince case, and that was one of the great cases of the 1990s, which basically said it's not quite that. I'm just going to differ with you slightly. I mean, it basically says that the state governments and state government entities can't be co-opted by the federal government to serve their powers, and I think that is certainly an important principle, and it gets at a lot of these things. The problem is that there's still a lot of Supreme Court case law which says that the federal government can coerce the states to be, to engage in these things, either through block grants or what have you. And the states are free to say no. I will say this much. It's funny. I remember a couple of years ago on Constitution Day, I was working for a radio station in Baltimore, and a colleague of mine asked me what my favorite amendment was, I think expecting me to say that the Second Amendment. And I said the Ninth, because I'm a huge devotee of the Ninth Amendment, which of course says that the enumeration of certain powers in the Constitution are not meant to deny or disparage the existence of others. And to me, that gets to this idea that even if we didn't have a Second Amendment saying that, giving this one justification for the right to keep and bear arms, you would still have the right to keep and bear arms because you hadn't ceded it away to government. I think that a greater invigoration of this obviously would enhance cooperative federalism. It would put states like California at a disadvantage. It would also get us at these issues that I talk about, which is we lost Blaze.
We did. We lost him.
All right. Well, we'll get him back in a second.
I'll fill him in if not.
So this idea of and now I forgot my train of thought. This idea of as a cooperative federal
Ninth Amendment. Yep.
So we get to that, but there are no easy solutions. This is what I'm saying when I say that we had 60 years between the New Deal era Supreme Court decisions affirming the expansion under duress, by the way. I mean, let's not forget that, to the first cases in the 1990s saying no, there are limits, whether it's New York versus United States or Prince, or the certain wetlands cases that were out there. I mean, these were really exciting times when the court sort of stepped up there and said, "Yeah, there are limits to federal power." So.
Yeah, and I think that's a lot of what we touch on here all the time. Right. I mean, obviously you're dealing with this all the time, the federal overreach. And, I think a lot of what we do, and I'm sure a lot of what you do, is really just trying to wake people up to that, because the more people that are engaged with this and are constantly thinking about it, the better chance we have of making these changes.
Let's start here with this idea of, let's just assume for a moment, right? And I'm a firm believer in Hanlon's razor. Hanlon's razor says, never attribute to malice that which can just as easily be attributed to stupidity. Let's say for a moment that all federal regulations are justified, that they all serve a purpose. I don't believe that, but let's just say for a moment that we do agree on that. Then the goal should be compliance, not punishment. And if the goal is compliance, then getting regulated entities to understand what all their obligations are so you can't play this gotcha game, that should be the business of government. And that gets into this idea of creating a system where the regulated community is informed. I mean, that gets to a lot of this burden that we're talking about, which is, some of it's education, self-education. Some of it is the time spent filling out paperwork, right? You're doing the research, you're hiring the professionals. Well, if you didn't have to do all that, now, sure, the regulatory professionals, the lawyers, the accountants, they would all be really upset about this. I don't particularly care one way or the other. I don't believe in sort of make work. So let's get at that. There was a really great effort, again, during the George W. Bush administration, called OSHCON, the OSHA consultative process. And OSHA was really what President Reagan had in mind when he said, those most hated, feared words that a business owner hears. I'm from the government and I'm here to help. Right? You get an OSHA inspector show up and you're going to get dinged. Well, what if the goal is workplace safety? What if a small business were given the opportunity of having a free inspection, where the OSHA inspector tells you what's wrong, gives you X number of days to fix it. They'll come back and they'll review it. And if you've fixed it all to their satisfaction, you've made this effort, you get a certificate which turns around and gives you a rebate on your workman's comp insurance. You incentivize compliance.
Sure.
And that's, this idea of a cooperative approach. Again, recognizing that not all regulations are created equal, that not all of them are great, not all of them serve a purpose. In fact, a number of them, the Endangered Species Act is a prime example, do the opposite of what they intend. My favorite, I don't know if you've ever heard of the phrase of a contronym, CONTRANYM. These are words that have two different but opposite meanings, like cleave and cleave. Cleave either means to join or cleave means to separate, etc.
Sure.
Regulations that serve to run counter to other regulations. I was explaining to somebody today, the EPA at one point was very concerned about dust and particulate matter and passed some new regulations to deal with particulate matter, dust. And so a lot of businesses were forced to pave over their parking lots in rural America to abate for dust. Well, once they paved over their parking lots, that created all of this impervious surface that, because of the rain tax under the Safe Drinking Water Act and stormwater management, they were taxed based upon their impervious surface area. So they had it going, they had it coming. Well, maybe we should be taking some efforts to make sure that these regulations aren't in direct conflict with each other.
Yeah, absolutely. That's a great point. Oh, he's back with us. There he is.
I have no idea.
It's happened.
Riverside.
Yeah,
it's out of my realm.
Yeah, no worries. You're back, and he did answer the rest of your question. I
will repeat the answer now. No, I won't.
He can listen to it back.
the whole 7 minutes worth.
Yeah.
Good.
So like you said, before you hopped off there for a second, Pops, we are already at an hour, believe it or not. Flew right by. Are there any more questions you want to get in, Dad, before we wrap it up with Andrew for the night?
Well, the only thing, Andrew, I think would be important. We very much encourage activity from our listeners,
right.
And if you were able to give a couple of quick pointers on how people could be involved, 100%. How people could get out there and be a part of the solution to this particular issue.
Without a doubt. Now, I taught on this for a couple of years, on the regulatory process. And the very first thing that I would do with my students is I would get them to go and visit a website called regulations.gov. That's regulations.gov. And or just about every, let's say 99% of all regulatory proposals are put up on regulations.gov, and they organize it so you can see what's just come open for comment and what's just come closed for comment. And I would have my students go through and pick one new regulation and one that was about to come closed, and I would have them summarize it. And the idea was to give these, 20-somethings, late teens, early 20-somethings, an understanding of just how vast the federal government is and how involved it was and the widest variety of things, habitat for an endangered squirrel, or drawbridge openings, or cars, and things with that. So I urge people to go and look at regulations.gov. Make that a part of of your daily routine. We're starting to put out there on our website, the CPAC Foundation Center for Regulatory Freedom, what's come open. But I behoove folks, because there's stuff that we missed. Go and look and see what's out there, and file comments. And if you see something you think I ought to be commenting on, let me know. If you don't have the time or you don't have the expertise, let me know if it's something important or if you want to add something, because that's what the agencies, that's the process by which they make these decisions. They go through and they make these recommendations. And I got to tell you, it's so funny. I have a research assistant. She does great work, and she never feels more powerful than when an agency responds to something she has written and has made changes to reflect that. If you say something of substance, right, you raise a concern, the agency is required by law to tell you what they've done to change their proposal, or give you the reasons why they didn't. And if they don't give you a good enough reason or they don't respond, that's the grounds you have to challenge what they're doing, right? The standard is the agency, what they're doing, is it arbitrary, right? Is it just without sort of any justification? Is it capricious? Is it being taken without sort of a thorough understanding of the situation? Is it an abuse of discretion, right? Does it not comport with what we've been talking about, the enumerated powers, or otherwise not in accordance with the law, that it somehow otherwise doesn't fit into these things? That's the standard that we use under the Administrative Procedure Act. So go and check out regulations.gov. Go see what's out there. That's the best way to be empowered in all this.
That's a fantastic solution to offer to our listeners. We are, like you said, we're always trying to give ideas of different ways you can get involved, and that's one that you really can just jump right into it. I mean, today. So that's awesome. Thank you for that.
You're welcome.
Yeah, absolutely perfect. You can do it from the comfort of your home. You can do it if you have 5 minutes at the office. You can jump on during your lunch break. You can get involved by participating in pointing out things that real people deal with the regulations that are unending.
Absolutely. Yeah. That's how they find out, what the nonsense that folks have to deal with in the real world, right? Anyway, yeah, absolutely.
Awesome.
Perfect. Yeah. Well, it's been such a fun conversation, Andrew. You've given us so many different things to think about and just really dove into a world that we don't have firsthand experience with. So we thank you a lot for that. Before we go, I'd certainly love for you to give everybody, all the info of where to find you, your different shows, the different projects you're working on, all that good stuff.
So the best way always to follow me or to find me is to follow me on Twitter or X at Andrew_Langer, Langer. That really has everything that I'm doing sort of updated constantly. I run the Center for Regulatory Freedom and the Coalition Against Socialized Medicine at CPAC. You can find the work there. But I almost always link to that stuff through Twitter. I do a lot of radio. In fact, the last week of June, first week of July, I'm going to be doing a number of shows syndicated in the Midwest and then in Washington, D.C., invariably doing that. Andrew and Jerry Save the World is the podcast I do with the editor of Real Clear Policy. And then I do a weekly podcast for the Federal Newswire called The Lunch Hour. It's a deep dive into public policy. This week and next week, we're doing a series on something called the REINS Act, which is, again, a way of turning the burden on its face. This would require that if you have a major rule, a regulation that's going to cost the American economy at least $100 million a year or more, that before it can be implemented, it has to pass Congress. I'm doing 25 interviews in 10 days on the REINS Act. The first 7 are up. I think that they're fascinating and well worth watching. So go and check that out. The Lunch Hour at Lunch Hour Pod is the website.
Perfect. That's awesome. Thank you so much. Yeah, we'll definitely post all of that stuff in the show notes.
Thank you, guys. Blaze, happy birthday.
Yay. Andrew, thanks. It was nice to meet your puppy dog there. Yeah. And we certainly enjoyed having you on. We'll keep our listeners posted about your activities. We will continue to mention regulations.gov.
Thank you.
Awesome place where folks can get involved very easily.
Thank you. Thank you. And listen, guys, anytime you want me back, just let me know. As I said, always happy to talk about myself.
Well, we'll definitely keep you posted on that. We'd love for you to join us again. Right. Thanks so much, Andrew.
Take care, guys.
Bye-bye.
Thank you. I do have a verse.
Yeah, perfect. We wrapped it up so quick there. He didn't even get to join us. So go ahead and close us out with that before we close for the evening.
Yeah, so the Lord is near to all who call on him, to all who call upon him in truth. Psalms 145:18. I hope that's not one I used recently. Great show tonight. That was a good catch. There's some really heavy duty stuff there. I think much of the time, many of us are looking for simple solutions boiled down to, the original founding documents. But as you suggested during the conversation, it is so big, so unwieldy. You just can't go in there and cut off all of these things, or perhaps the whole thing would come to a screeching halt, although that's what some of us would subscribe. But he was certainly very well dialed in on the impact of regulation on everybody's lives, and how, like with the medical thing he suggested there, and he's doing a show that is hopefully working on pushing an act that would hopefully slow down or cut out a lot of this regulatory nonsense that we're all forced to deal with.
Yeah, exactly. It goes back to a lot of things that we've said many, many times on the show in many different episodes. How many times have you said free men don't need permits? This really gave us the opportunity to dive into those permits and all these things that people don't really think about, especially, he gave great examples for people who are affected firsthand if they're a property owner, like our friends in South Dakota. He gave great examples if you're a small business owner. But if you don't fall into one of those categories, you don't see a lot of this stuff affecting you or anyone you know. So you don't understand what's going on. His entire life's work is about this stuff. So it is a very real thing. And, regulations.gov, again, great place for you to get involved in a very simple way. Find one thing that's meaningful to you and comment on it, because it, to his point, does have meaning and it will change the course of what happens next. And I think if all of us take these small steps, that's all it takes. And yeah, I mean, we can't get rid of the federal government overnight as much as we'd like to. Maybe it'll happen soon. We don't know. But
Yep.
There's plenty of other outside factors at play there. But as far as the things we can do, this does fall into that category. And I certainly want to be able to do everything I can because there is so much overreach and we barely skimmed the surface tonight. So thank you for the Bible verse to close us out. That's our very last thing. We kind of are just going and going here.
Yeah.
But another great Bible verse, obviously, with all of these things, if truth is at the core of what you're doing, the right answer will be in your heart and in your mind. And you shouldn't have to look any further than that. So again,
Amen.
Pops, happy birthday. I'm so glad we got to spend it on the fourth box, of course.
Yeah.
What better way?
It was a great time being with you and with our guest. Another great show tonight. Look forward to what next week brings.
Yeah, that's right, everybody. So until next week, keep an eye on the show notes for all the information on Andrew, everything he's doing. We'll share that information down below, and stay vigilant.
Stay vigilant. Good night.
Thank you so much for listening. We really do appreciate the support and truly love getting to share this message with anyone who wants or needs it. The best way for you to support the show is to subscribe, add a rating, and share with everyone you know. You can find us on Instagram, X, and at thefourthbox.com. We'll see you next Thursday at 6 p.m. Stay vigilant.